Today I am going to discuss a topic related to cases under section 138 of the Negotiable Instruments Act 1881. I am discussing a case disposed by the Honorable Judicial First Class Magistrate Court resulting in the acquittal of the accused, against which the complainant has preferred an appeal to the High Court. In this case, the complainant filed a case under section 142 of the Negotiable Instruments Act in the Magistrate Court. Section 142 of the Negotiable Instruments Act deals with the cognizance of offences. Section 142 deals with notwithstanding anything contained in the Code of Criminal Procedure 1973, now BNSS 2023. A. No court shall take cognizance of any offence punishable under section 138 except upon a complaint in writing made by the payee or, as the case may be, the holden due course of the cheque. The complaint in writing is necessary according to this section. B. Such a complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso to section 138. Provided that the cognizance of a complaint may be taken by the court after the prescribed period if the complainant satisfies the court that he had sufficient cause for not making a complaint within such a period. I am not going to discuss this section in detail because we want to discuss more about other aspects of Negotiable Instruments Act. As per the Negotiable Instruments Act, to file a case under section 138, the cheque must be presented to a bank and dishonored. After dishonor, a notice is compulsory and a time frame must be given for a reply. Only then complaint be filed under section 138 of the Negotiable Instruments Act. A case came up before the Honorable Judicial First Class Magistrate Court involving a cheque dispute. The cheque in question was for 40 lakhs presented by the complainant to the State Bank of Travancore, which was subsequently dishonored. The bank issued a dishonor memo prompting the complainant to send a legal notice. The accused responded with a reply notice. In the reply notice, the accused alleged that the complainant he owed only 4,70,000 rupees and returned the same with interest of amount 7,29,028 rupees. Also, he claimed that 2 blank checks were provided at the time of the borrowal, which the complainant allegedly misused. Today, I am discussing a scenario where someone gives a blank check and he later fills in a larger amount and presents it to a bank. If the check is subsequently dishonored, can he file a complaint under section 138 of the Negotiable Instruments Act, whether he succeed in his claim? So it's like a business. We can make money. For example, if I have only 20 lakhs assets, I have given some amount of money to other person and I obtained a blank check from him. Can I fill in 20 crore rupee in that blank check and present it to the bank? And after dishonor, can I file a complaint before the court for this 20 crore rupees? It's a huge amount of money. We can make money if we obtain a blank check, and legally we can get money from the opposite party. Is it possible? We are discussing the consequences of obtaining a blank check and filling it in with a large amount. Here we are discussing a case. In this case, the accused was acquitted. Let's discuss how the accused proved his innocence and what factors contributed to the acquittal. In this case, the total 8 witnesses were examined by the complainant. 10 documents were marked as evidence, and ultimately the court acquitted the accused. The reason for the acquittal is that the complainant failed to prove that the cheque amount was issued for a legally enforceable debt. For that acquittal, aggrieved by the complainant, he prefer an appeal before the High Court. In the appeal, the complainant's contention. As appellant, his contention is that he successfully proved the execution of the cheque. Once the execution is proved, the burden shifted to the accused to rebut the complainant's evidence. There is a presumption under section 139 of the NI Act. We want to discuss 139, then we can understand that what is this section mean for. 139, presumption in favor of holder. It shall be presumed unless the contrary is proved that the holder of a cheque received the cheque of the nature referred to in section 138 for the discharge in all or in part of any debt or other liability. So if complainant proves the execution, the burden shifted to the accused for rebutting the presumption under 139. This is a presumption under 139 of the Negotiable Instruments Act that supports the complainant's claim. The court presumes that the complainant's case is true. The complainant complied all the formalities specified under section 138 of the NI Act. So the burden shifted to the accused to prove his case. In this case, the accused failed to rebut the evidences produced by the complainant. Yet the court still decided in favor of the accused, which may have been a wrongful decision. So he preferred an appeal. As per section 139, the court presumes that the cheque was received by the holder for discharge of a debt or liability. If the execution of the cheque is proved, the court presumes everything in favor of the complainant. The court believes that the complainant's case is true, specifically that the cheque was issued for discharge of a debt or liability. The complainant has completed all the formalities under section 138 of the NA Act. If the complainant proves the execution of the cheque, the presumption under 139 favors the complainant. To counter this, the accused must rebut the presumption by presenting evidence to prove their case in court. Here, to rebut the presumption, the accused deploy various defenses, like claiming that the borrowal amount with interest has already been repaid, also alleging that the cheque was lost from his hand and subsequently obtained by the complainant and misused it. Sometimes he entrusted his cheque to his friend, who then passed it to the complainant, leading to misuse. So all defenses taken by the accused to rebut this, because there will be a question from the court that how the complainant obtained your cheque and produced before the court. For answering or rebutting this, the accused should have adduced his defenses. For that, he preferred these kind of defenses. Sometimes he taking some defenses like a blank cheque was given to the complainant. At the time of borrowal of money, he repaid the entire amount, but later the complainant misused the blank cheque. Like these defenses were taken by the accused for rebutting the presumption under section 139. In criminal cases, the prosecution must prove guilt beyond reasonable doubt. Like rape cases, like murder cases, assault cases, the prosecution should prove their case beyond reasonable doubt against the accused. However, in cheque bouncing cases, which falls under criminal cases, the standard of proof is relatively relaxed. The primary objective of the 138 cases, means Negotiable Instruments Act cases, is for compensation, not for punishments. Sometimes court gives lesser punishments. Main objective is giving compensation to the complainant. Therefore, the courts may consider evidence based on probabilities, like preponderance of probabilities, rather than strict proof. Here, the complainant alleged that he had successfully proved the execution of the cheque, but the accused failed to effectively rebut the evidence. So, the complainant's arguments, the trial court wrongly acquitted the accused without properly considering the evidence presented. The accused claimed that he borrowed 4,70,000 rupees and repaid 7,29,028 rupees with interest, and gave 2 blank checks as security, which were allegedly misused by the complainant. The complainant proved the execution, means check's execution, shifting the burden to the accused to prove their defense. The accused argued that he successfully rebutted the presumption under 139, shifting to the burden back to the complainant. If burden back to the complainant, he will not get another presumption under section 139, means no longer the presumption will helps him. So the complainant cross-examine the witnesses produced by the accused and also evidences produced by the accused, and to prove it is false. Here the complainant alleged that they are friends. The accused borrowed small amounts of money from time to time. However, the accused later borrowed a significant amount of 49 lakh rupees. This huge amount of money arranged by the complainant by borrowing from relatives and his friends. This said amount was partly paid through bank accounts and partly through direct cash transactions. The complainant husband was aware of these transactions and urged the complainant to recover the borrowed amount from the accused. Consequently, the complainant requested the accused to repay the money. When the complainant demanded repayment, the accused issued a cheque worth 40 lakhs. This is a case of the complainant. The accused claimed that he borrowed only 4,70,000 rupees and repaid 7,29,028 rupees with interest. At the time of borrowal, he entrusted 2 blank checks, signed papers as security to the complainant. However, complainant allegedly misused those documents. The accused filed a complaint with the superintendent of police, alleging that the complainant had misused the check by filling in a large amount to extort money from the accused. During the cross-examination of the complainant testified that 9 lakhs out of 49 lakhs was handed over to the complainant, and the accused provided a check for 40 lakhs. However, this fact was not mentioned in either the legal notice or complaint presented before the court. The complainant admitted that the accused had already repaid 7,29,028 rupees. And also the accused counsel asked at the time of cross-examination whether any complaint made by the accused against you. The complainant initially denied it, but later admitted that the accused had indeed filed a complaint against him. The income tax returns produced of the complainant produced the said amount not reflected in the income tax returns. The accused counsel cross-examined and asked a question that what was his job at the time of the money transaction. The complainant replied that he had no job at that time. The complainant alleged that he borrowed money from relatives and friends to lend to the accused. However, when the relatives and friends were examined in court, it was revealed that they had only lent 14 lakhs to the complainant. One relative of the complainant, examined as PW2, he deposed that he had given 3 lakhs to the complainant and witnessed the complainant lending money to the accused. The complainant's sister also examined in court. She testified that she gave 3 lakhs to the complainant and had witnessed the transaction in between complainant and accused. The complainant's brother-in-law also examined. He testified that he gave 5 lakhs to the complainant and witnessed the complainant handing over the money to the accused. The complainant's neighbor was examined. She also testified that she gave money to the complainant and witnessed the complainant give the money to the accused. The complainant servant was examined. She testified that she witnessed the transaction between the complainant and the accused. 2 bank managers were examined. One from the accused bank and other from the complainant's bank. In the complainant's bank, the account name is in the name of an enterprises. The complainant represented as the proprietor of the enterprises. A subsequent affidavit filed by the complainant regarding this. During the cross-examination, the complainant admitted to having knowledge of being the proprietor of the enterprises for only 2 days prior. In further evidence, a registration certificate issued by the Kerala Government Commercial Taxes Department was produced in the name of that enterprises. After cross-examination of the complainant, there are a lot of doubts were created by the accused for rebutting the presumption under section 139 through preponderance of probabilities, not strict proof of evidence. These are the doubts created by the accused after cross-examination of the complainant. 1. The complainant's evidence regarding the payment of money to the accused lacks credibility as there are many ambiguities in her depositions. Second, the complainant had not stated any reason as to why huge amounts were lent to the accused without even letting her husband know. Third, though PW 2 to 5 stated that they had advanced 14 lakhs to the complainant during different transactions, they did not place any material to establish the same. She had no job during the relevant period. 4. The complainant failed to give convincing evidence as to how she had advanced money to the accused. 5. The complainant did not state the transactions in the income tax return submitted by her. 6. The complainant had no idea about the transactions amounted rupees 3,15,300 from the account maintained in the name of that enterprises. 7. PW 2 to 7 stated only about the payment of 40 lakh to the accused, whereas the complainant herself admitted that the accused had paid back more than rupees 7 lakhs. This makes the defense case more probable. 8. Though the complainant initially denied the registration of a police case against her alleging charging of exorbitant interest, in the subsequent stage of her cross-examination, she admitted the same. 9. The evidence of the complainant that she came to know about the fact that she was the proprietor of that enterprises only 2 days prior to her examination in the court makes her version doubtful. The accused admitted the signature in the cheque belongs to him but denied the contents of the cheque. Next, we will discuss the presumption regarding the consideration, specifically under 118 of the Negotiable Instruments Act, that is 118A presumption. In 118, presumptions as to negotiable instruments. Until the contrary is proved, the following presumptions shall be made. A. Of consideration. that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. And other presumptions are as to date, as to time of acceptance, as to time of transfer, as to order of endorsement, as to stamp, that holder is a holder in due course. Today we are only discussing 118A of consideration. The complainant proved that the check was presented to the bank and subsequently disowned. This act is sufficient to raise a presumption regarding consideration, that is 139 presumption. The complainant also proved the execution of the check, specifically that the signature on it belonged to the accused. The accused also admitted that the signature belongs to him. The complainant's testimony about seeing the accused sign or acknowledging the signature is sufficient to establish execution, since the accused admits to the check and signature. Proof of execution is not required. Execution proved. Once the execution of the check is proved or admitted by the accused, the burden shifted to the accused to prove that the check was not issued for discharging a debt or liability. A presumption is an inference or conclusion drawn from proven facts or circumstances. If the accused fails to rebut the presumption, the court will draw a conclusion in favor of the complainant. To overcome this presumption, the accused must prove their case to rebut the presumption. To rebut the presumption, the accused doesn't need to prove their case beyond doubt. Instead, they must show a preponderance of probabilities that a prudent person can understand. A judge is like a prudent person, will assess the evidence based on ordinary good sense. When the accused successfully rebut the presumption of consideration by showing it improbable, doubtful or illegal, the burden shifts back to the complainant. If the complainant fails to establish consideration, they may not get the benefit under Section 139 Negotiable Instruments Act. The presumption again helps him. To prove the non-existence of the consideration, the accused can rely on evidence presented by the complainants, records produced by both parties, complainant's testimony, cross-examination, the plea of the accused, defense evidences. Everything can be used for rebutting that presumption. The accused doesn't need to prove their case beyond reasonable doubt. Instead, he can rely on the probabilities, preponderance of probabilities, similar to civil cases. The accused can take two probable defenses, like 1. The debt or liability never existed. 2. The debt existed but has been repaid, which can be proven through a preponderance of probabilities. The accused can use various documents and evidence, such as complainant's evidence, legal demand notice, complainant's testimony, cross-examination, and plea to establish a probable defense and to prove the non-existence of the debt or liability through a preponderance of probabilities. For rebutting of presumption, a lot of judgments were discussed in this judgment. We can discuss those judgments also. Uttam Ram versus Devinder Singh Hudan and another. A negotiable instrument, including the check, carries presumptions in consideration in terms of Section 118A and Section 139 of Negotiable Instruments Act. Dishonor of a check carries a statutory presumption of consideration. The holder of the check in due course is only required to prove that the check was issued by the accused and that when the same was presented, it was not honored. Since there is a statutory presumption of consideration, the burden is on the accused to rebut the presumption that the check was issued not for any debt or other liability. T. Vasantakumar versus Vijay Kumari. The Supreme Court held that since once the check as well as the signature are accepted by the accused, the presumption under Section 139 of the NA Act would operate and the burden is on the accused to disprove the existence of any legally recoverable debt or liability. In Tengampa versus Mohanan, the Apex Court held that the presumption under 139 of the NA Act does include the existence of a legally enforceable debt or liability. Therefore, I am of the view that the complainant has established the execution of P1 check by the accused. Next case is Haitan P. Dalal versus Bratindra Nath Banerjee. This is a Supreme Court decision on the scope of Section 138 and 139 of the Negotiable Instruments Act held that the obligation of the prosecution may be discharged with the help of presumptions of law or fact unless the accused adduces evidence showing the reasonable possibility of the non-existence of the presumed fact. Bharat Barrel and Drum Manufacturing Company versus Amin Chand Parela. While considering the presumption under 189 of the Negotiable Instrument Act, the Supreme Court observed that if the defendant is proved to have discharged the initial onus of proof showing that the existence of consideration was improbable or doubtful or same was illegal, the onus would shift to the complainant, who would be proved it as a matter of fact, and upon its failure to prove would disentitle him to the grant of relief on the basis of the negotiable instrument. The Supreme Court further observed that the burden upon the defendant of proving the non-existence of the consideration can be either directly or by bringing on record the preponderance of probabilities by reference to the circumstances upon which he relies. Next case is Harbhajan Singh vs. State of Punjab. Supreme Court decision: while considering the nature and scope of onus of proof which the accused was required to discharge in a criminal case, held that the onus on an accused person might well be compared to the onus on a party in civil proceedings, and just as in civil proceedings, the court trying an issue make its decision by adopting the test of probabilities. M.S. Narayana Menon vs. State of Kerala. Supreme Court has elaborately considered the question of standard of proof for rebutting the mandatory presumption drawn under Section 139 of the Negotiable Instruments Act. In Narayana Menon, the Supreme Court held that if some material is brought on record consistent with the innocence of the accused, which may reasonably be true, even though it is not positively proved to be true, the accused would be entitled to acquittal. The Supreme Court further held that it is not necessary for the accused to disprove the existence of consideration by way of direct evidence, and that the standard of proof evidently is preponderance of probabilities. In Rajesh Jain versus Ajay Singh, the standard of proof to discharge this evidential burden is not as heavy as that usually seen in situations where the prosecution is required to prove the guilt of an accused. The accused is not expected to prove the non-existence of presumed fact beyond reasonable doubt. The accused must meet the standard of preponderance of probabilities, similar to a defendant in a civil proceedings. So in this case, after considering all the evidences, the pleadings and evidence on the touchstone of the precedents referred to above, the specific case of the complainant is that she advanced a sum of more than 49 lakh at different intervals to the accused. She further pleaded that the amount was rounded to a lower figure by fixing the liability at 40 lakh. According to the complainant, the discharge of this liability, the accused executed Exhibit P1 check. While examined in cross, the complainant stated that she had advanced a sum up to 49 lakh. She further stated that the accused had returned 9 lakh. The complainant did not state regarding the return of 9 lakh by the accused either in the complaint or in the affidavit filed in lieu of chief examination. At one stage of her cross-examination, she deposed that she did not state either in the complaint or in the affidavit in lieu of chief examination that she had advanced more than 49 lakh. The circumstances brought out in evidence point to several suspicious circumstances referred above. The onus has now shifted to the complainant. She is obliged to prove the existence of a debt or liability as a matter of fact. The presumption under 139 does not again help the complainant. In the present case, the complainant failed to prove the same. I am of the considered view that the accused has satisfied the court that there was a reasonable probability of the non-existence of the consideration. The necessary conclusion is that the accused has successfully rebutted the presumption drawn in favor of the complainant. The accused, having been acquitted by the trial court, is entitled to the presumptions of innocence. The view taken by the trial court cannot be held to be illegal, improper, or contrary to law. The reasoning recorded by the trial court for acquitting the accused was possible and plausible, and no interference is required. The appeal stands dismissed. After examining all the evidences and suspicious circumstances, the High Court has confirmed the trial court's decision to acquit the accused. I am creating law videos to raise awareness among the general public, and we are discussing this for enhancing our legal knowledge. I am also posting law related videos through this channel. If you like them, please share, subscribe for more content.